All right, good afternoon. It is May 1st, 2020. We are here for this week's Economic Justice Law Review, Weekly Scholarship Review. So that's where every week I come on here and I talk about scholarship that's been published in law journals and reviews and other academic journals, searching for papers that impact on race, economics, and the law. Now, they don't have to necessarily say themselves race, economics, and law. We have a framework where we can take basically every racially subordinating circumstance and express it in economic terms, which I call racially asymmetric market imperfections. In other words, the free market or the supposed free market assumes that everyone is a profit maximizer, that there is perfect competition, that there is perfect information, and that there are no transaction costs. And if those things exist, the market will distribute goods and resources fair and meritocratically. However, if we know that information is not only imperfect, asymmetrically imperfect with respect to race, if we know transaction costs and society's externalities exist, and yet they're asymmetrically distributed with respect to race, if competition is imperfect because of capital gaps, but it's asymmetrically imperfect because of the racial wealth and capital gap, and again, if certain folks are encouraged more to participate in the market and maximize profit more than others, then again, we have an asymmetry with respect to profit maximization. So racially asymmetric market imperfections refers to racially asymmetric market information about and available to black people, racially asymmetrically distributed transaction costs and societal externalities, racially asymmetric market competition in labor markets, commercial markets, and others, and also racially asymmetric commitment to market engagement. And so we take articles that are very good articles that have been published in the law schools, law reviews and journals around the country, and we recharacterize them in that framework and bring them to you each week. So without further ado, the featured articles for this week first would be Megan Barry and Richard Weiner on ex-offender housing discrimination. So they have done some statistical analysis on stereotypes and ex-offender housing discrimination and stigma. So we'll talk about that first. We'll talk about Crozier and Garrett, William Crozier and Brandon Garrett from Duke on the effects of driver license suspensions. And this is very dear to my heart because, of course, I published a book called Taxes, Death, and Trouble, which recharacterizes criminal justice fines, forfeitures, and fees as regressive and racist taxes to the extent they're not designed to protect the public safety, and to the extent they are designed to raise revenue. Then they are taxes, even if they are informal taxes, and they are regressive to the extent they are levied on poor people more than rich people, and they are racist to the extent they are disproportionately leveled on poor black people versus poor whites. So Taxes of Death and Trouble talks about regressive and racist taxes in the form of criminal justice, fines, forfeitures, and fees. This paper talks directly about driver license suspensions, which also, I guess, in a sense, is a heightened transaction cost for crime if it is if they disproportionately suspend black licenses or Latino licenses, people of color. And then finally, the feature for this week, a fantastic paper about what's coming next. Jason Bent on algorithmic affirmative action, published in the Georgetown Law Journal 2020. This is hot. This is fire. We're talking about artificial intelligence and machine learning. I can't wait to get to that. So without further ado, let me remind you of the papers that we talked about last week. So if you're interested, I just want to make sure you recall we did Paul Mollica's The Unfinished Mission of Title VII, Black Parity in the American Workplace, in the Journal of Gender, Race, and Justice. That's a powerhouse paper on Title VII that is a great precursor to this talk about algorithmic affirmative action, because we're talking about machine learning in the hiring context and perpetuating racial biases there under Title VII. So this is a great follow-up from next week. Last week we also talked about another fantastic paper, Peter Nicolas's Reconstruction, which dealt with the reconstruction of civil rights statutes through novel interpretations that purport to be intentionalist, that purport to follow stare decisis, but cites dissents, concurring opinions in ways that transfer the meaning of law without repealing cases, right? So by subterfuge, more or less. And then William Sabol's Trends in Correctional Control by Race and Sex, which actually was a very positive paper in that it demonstrated that the incarceration rates for black men and women have gone down relative to white men and white women, which is not entirely a success story because we're not out to celebrate other people's demise or downfall, in that these numbers reflect the methamphetamine I want to call it, it's hard to call it an epidemic while we're dealing with this pandemic, but the methamphetamine problem that's on rural America. Prior to that, we talked about Catherine Powell, Runoko Rashidi, Etienne Toussaint, Bernadette Tuaheni, Nancy Abuda, Ezra Rosser, Jennifer Pizzio, a lot of great works. Again, every week we are going to present probably 3 different pieces of scholarship that impact on race, economics, and law. So glad you joined us, and let's get to the first one. Okay, so first let's talk about Barry and Weiner's Barry and Weiner from University of Nebraska-Lincoln, and this is a psychological study. So it relates to the law, but it is by 2 psychologists, Megan Barry, Richard Weiner, Ex-Offender Housing, Stigma, and Discrimination. So my recharacterization of it in economic terms goes as such: to the extent ex-offender stereotypes disproportionately apply to black people, housing stigma and discrimination that follows from them represents asymmetrical transaction costs and externalities, in the sense that society, through its legislatures and government, set the price or social cost for illegal or illicit behavior, and that such transaction costs are higher for black offenders and ex-offenders than for others. And to the extent ex-offender stigma promotes the myth of black inferiority more generally, right, to the extent it's applied to people who aren't even offenders at all, it represents racially asymmetric market information about black people. The disproportionate capacity to obtain housing and the human capital emanating potentially therefrom exacerbates racially asymmetric market competition because it exacerbates racial human capital gaps. Remember, capital, we can distinguish between human, social, financial, and political capital. Yes, they bleed together, but the division in those 4 is fairly clean. Okay, so here's a little bit from the paper, Ex-Offender Housing, Stigma, and Discrimination. Despite the importance of stable housing for successful reentry, criminal history reduces the willingness of housing authorities to rent to applicants. In seeking to understand the systemic nature of housing discrimination, we documented the stereotypes that 445 community members hold about ex-offenders by applying stereotype content model analysis, sounds dope, to map beliefs prior to asking participants to make rental judgments. Results showed that people perceived released offenders as low in competence and warmth, and that the low competence stereotype diminished willingness to rent to ex-offenders. One way to combat that problem of ex-offender stigma in the domain of housing is legislative action. So there we get the psychology matched with the law. That includes criminal record as a protected class. And that adds a direct enforcement mechanism to anti-discrimination law. Instead of aspirational rules and guidelines, concrete rules with clear consequences against using a criminal record as an arbitrary decision-making tool in determining rental status would go a long way forward toward improving ex-offender re-entry by muting the impact of stigmatizing stereotypes. Simply put, Congressional legislation revising HUD guidelines would strengthen HUD's ability to restrict housing discrimination against ex-offenders that arises out of the kinds of stereotypical thinking that we showed here and that field studies have documented in more ecologically valid demonstrations may be the best way to prevent stigma from disadvantaging ex-offenders in the housing market. To close it out, these legal changes will most likely evolve slowly, but the pace may be accelerated if more psychologically based research addresses this problem, exploring theoretical explanations for the stigma that people face after they have served their debts to society. So again, very interesting paper. That shows or demonstrates the extent which these stereotypes track black offenders, black and brown offenders, and therefore represent asymmetrical criminal justice penalties or asymmetrical transaction costs, right? We're just recharacterizing it in terms of the structure of the free market. So it tells you how you are disparately being treated now, and it also demonstrates how the free market is skewed and will perpetuate and exacerbate racial subordination economically in the future. Okay, the second paper, Crozier and Garrett on the effects of driver license suspension. So this has a more direct relation. You can see a more direct relationship to economic justice and the widening of the racial wealth gap when these penalties are applied disproportionately. This paper is by William E. Crozier and Brandon L. Garrett, Driven to Failure, an empirical analysis of driver's license suspension in North Carolina. It's in the volume 69 of the Duke Law Journal, page 1585, 2020. And put simply in economic terms, to the extent driver license suspensions are more disproportionately levied upon black offenders, it on the one hand represents asymmetrically distributed transaction costs, just as we talked about with housing stigma, right? If society and legislature set the price for illicit behavior through the criminal justice system, then the disproportionate distribution or the disproportionate levying of those costs is represent asymmetrical transaction costs and externalities, and also shows how the free market is degraded thereby. We could also say that because driver's licenses affect ability to compete in the labor market, that they also exacerbate racially asymmetric market competition in those labor markets. So here's a little bit from the paper. First of all, it's part of a symposium at Duke, Fees, Fines, and Bail Symposium, addressing the destitution pipeline. Of course, I would call it, just in tune with my book, Taxes, Death, and Trouble. Those are absolutely, when they say bail symposium, that's what we're talking about, bail forfeiture. We're also talking about civil asset forfeiture. And then if we talked about taxes, death, and trouble, we would also include poll taxes that are used to then squelch the black vote and recertify and reinvigorate the fees, the fines, and the bail and civil asset forfeiture. So that's why I think it's all lumped together as taxes. All right, a piece from the paper. A person's interest in a driver's license is substantial, and as the U.S. Supreme Court has observed, the suspension of a license by the state can result in inconvenience and economic hardship suffered, including because a license may be essential in the pursuit of a livelihood. However, 44 states currently require indefinite suspension of driver's licenses for non-driving related reasons, such as failing to appear in court or pay fines, or for traffic infractions. So if you get fines, fees, and forfeitures, and you're not able to pay, and you skip that court date, not only are you likely to get a warrant for your arrest, you're likely to have your driver's license suspended, and then your ability to pay the debt you owe severely hampered and hamstrung, which would then result in incarceration and the state selling your labor for you. This study describes North Carolina's population of suspended drivers and assesses how driver's license suspension statutes operate relatively relative to geography, race, and poverty level. This study reveals that driver's license suspensions are not associated with either the volume of traffic stops or the size of the traffic court docket. In contrast, we find that Black and Latino people are overrepresented relative to the population. We knew this. But you need the numbers to back it up. If a court of law, we're in an age, or we were in an age of what's called scientific realism, where courts would in fact deal with the purposes and the consequences of the law so long as they could cite to scientific studies to back them up, rather than just your legal brief and expressing your view of the future. Now, it seems in the 21st century that even scientific realism has been discounted severely. But if it is to continue, it needs papers like this that speak the obvious in very precise terms. A little bit more from the paper. A suspended license can result in negative consequences ranging from job loss to restricted career opportunities to limited mobility, to name a few. However, until recently, all 50 states and the District of Columbia had in place laws that permit driver's licenses to be suspended or withdrawn for non-driving related reasons, including failure to comply with child support orders, failure to maintain proper insurance, failure to appear in court or pay fines for vehicular violations, and many others. In recent years, due to the legal challenges and the legislative change, several jurisdictions have removed such consequences. I believe California is one. I believe Pennsylvania is looking into it. However, 44 U.S. states still require suspension of driver's licenses for non-driving related reasons, indefinitely in 39 states. Policies related to failure to pay traffic fines or appear in court are not designed primarily for public safety, but rather to use suspension to induce payment and compliance. In that context, driver's license suspension is a state-employed debt collection tool. Again, taxes, death, and trouble. Remember, the sheriff of Nottingham, Robin Hood's foe, was a tax collector. Remember that. Existing data suggests that at least 11 million Americans, and perhaps far more, have suspended licenses. Here we expand our understanding of license suspensions by studying a new state, North Carolina, and modeling how race and poverty predict suspensions. A little more from the paper. We're going to take this a little further because I just find this very interesting, and I'll be including it in the next editions of Taxes, Death, and Trouble when I wrote it in 2017, and the information that's come out since then is just absolutely crucial to a proper understanding. So we'll be coming out with a second edition that includes Beth Colger's work and others. Fantastic stuff out there. These findings, the findings of this paper, have constitutional implications. The U.S. Supreme Court has repeatedly held that there is a constitutionally protected liberty and property interest in a driver's license that cannot be revoked or suspended without that procedural due process required by the 14th Amendment. That said, the court has approved post-suspension hearing processes, and at least for short-term suspensions, and lower courts have been divided in recent constitutional challenges to driver's license suspension schemes. What makes these findings particularly relevant, however, is not just the scale of the driver's license suspensions, but that they are disparately imposed on minorities and poorer communities. These findings have implications for equal protection and due process challenges, in which desperate enforcement of unfair procedures magnifies the constitutional harm. Indeed, some courts that have granted relief in constitutional challenges to driver's license suspensions have focused on an equal process theory in which both the equal protection and due process analyses play a role. So, very interesting paper by, again, this is published by William E. Crozier and Brandon Garrett, both of them of Duke University, published in the Duke Law Journal, Driven to Failure, an empirical analysis of driver's license suspension in North Carolina, 2020, part of a symposium that was entitled Fees, Fines, and Bail, Addressing the Destitution Pipeline. All right, so lastly, this paper is fire. It's fire. I mean, this is on the forefront of the battle with respect to the racial wealth gap, because Professor Bent deals with algorithmic racism or machine learning racism as it perpetuates implicit biases. However, it is very easy to read his paper and also for it to cover those that aren't inadvertent. that those that try to perpetuate racial subordination through subterfuge, through mechanisms that are racist but which are very, very hard to discover. So whether it's inadvertent and just perpetuating the biases that already exist, or whether it is actually purposeful and done under disguise or with subterfuge, this the machine learning, artificial intelligence is something that black folks have to be especially aware of in order to combat. This racial wealth gap that we're talking about also includes a racial technology gap if we're going to talk about market assumptions. And it can only get worse if we don't have the people that have or can watchdog these things. Now, this paper, I'm gonna let the cat out of the bag before I talk about it in its own terms, is also suggesting dealing with a more acute problem than that. That's the problem. This paper also presents the problems with the solution. This paper argues that the solution to machine learning reproducing biases is to race consciously program computers to combat those negative biases, but that intentional injection of race for positive purposes is vulnerable to constitutional attack under the Equal Protection Clause, right? Amazing. So let's go through it. This paper is fantastic. As a matter of fact, once you read this paper, or you have to also read Ruha Benjamin out of Princeton University. Ruha Benjamin's Race After Technology, the New Jim Code, hot, fire, gotta get it. So let me talk about this specifically. So again, this is Jason R. Bent. Professor Bent is, I believe he's the Associate Dean at Stetson. Shout out to Stetson. Is algorithmic affirmative action legal? Right? Is algorithmic affirmative action legal? And this was published in the 108th volume of the Georgetown Law Journal, page 803, 2020. My economic recharacterization of it goes as such. To the extent machine learning and corporate hiring perpetuates racial biases against black job applicants, it will maintain or exacerbate racially asymmetric competition in labor markets. Perpetuating racial stereotypes under the ruse of computer neutrality also reinforces the myth of black inferiority and thereby maintains or exacerbates racially asymmetric market information about black people generally. The concept of racially asymmetric market imperfections is designed to show why race-conscious algorithmic affirmative action should be permitted under the Equal Protection Clause as an anti-subordination principle rather than the toothless anti-classification principle. So again, this paper is fire. Is algorithmic affirmative action legal? He starts off talking about what is algorithmic affirmative action, describing what is meant by algorithmic bias, how machine learning is going to pick up on the biases of the programmers or previous decision makers, or even society at large, that if the decisions it picks up on are already tainted by race in any number of ways, it is just going to pick that information up, treat it as good, and then perpetuate it later. In other words, bad input, bad output. Then it's going to talk about algorithmic fairness. Again, how programming could consciously combat that with race-conscious tooling. But again, then it goes on to the statutory challenge to algorithmic affirmative action and whether or not it would be permissible under Title VII, whether it would be permissible under the Equal Protection Clause. So this paper is absolutely, absolutely terrific. So you'll have to forgive me, but I am going to read a lot from this paper because I just think it is so fantastic and encourage you to pick it up. And so some blurbs from the paper. Its introduction. Employers cannot use different and this is setting it up. This is setting up the issue before we get to the main issue. Employers cannot use different employment tests for different racial groups, right? That's a fact. Even if they might have good non-discriminatory reasons for doing so. Imagine that in making promotions to the rank of fire captain, the city of Springfield administers an exam with two parts, a written component and a field test component. And imagine that historically the city has weighted the written and field components equally, 50% each. Now, if the city obtains evidence that the written test is highly predictive of future success for white candidates, but not non-whites, and that the opposite is true for the field test, right? So we're saying that the written test accurately determines whether the white candidates are good, but it inaccurately deals with the black ones. And that the field test accurately deals with black folks, but the field test disfavors white people. Well, then they're saying that the test should be weighted differently, right? Then the city may have legitimate reasons for weighing the exam differently for the two groups. Based on its data, the city might want to weight the exam for white candidates at 75% written test and 25% for the field test, because that would favor what they're good at. But reverse those percentages for non-white candidates, 75% for the field test, 25% for the written test, because that's what they're good at. Right, so to play to each group's strengths, right, to minimize their weaknesses. The city may also have other reasons to weight components differently, including attaining diversity goals or avoiding disparate impact from equally weighted testing. Now, despite the city's legitimate ends, differentially weighting the exam according to race would violate Title VII of the Civil Rights Act and may also violate the constitutional guarantee of equal protection. A 1991 amendment to Title VII forbids adjusting the scores of or using different cutoff scores for employment-relating tests on the basis of race. The amendment banned the controversial practice of race norming aptitude test scores. Following the 91 amendment, employers may not use different test standards for different racial groups, even if there might be a legitimate business reason or valid affirmative action justification for doing so. Right? Now, what if instead of differently weighting two exam components, right? So that stuff is clear. We're not allowed to do that. But algorithms seem to be doing this under the cover of darkness. So what if instead of differentially weighting two exam components, the city wanted to make its promotion decisions using a machine learning algorithm or artificial intelligence, and that algorithm weighted some observed variables differently for white and non-white candidates? Machine learning is an automated process of discovering correlations that can be used to make predictions or estimates of some outcomes. So machine learning could have picked up without being told, without a programmer being racist or race conscious at all. The machine could pick up on the fact that black candidates do better in the field test, white candidates do better in the written test. It can do this without even being told to do it. So that's something that we have to keep in our minds when we're talking about this paper. The relevant prediction here is whether the applicant for promotion is likely to be successful in the position here of captain. The data made available to the algorithm when searching for correlations could include information about each applicant's race. In other words, the race variable could be used by the algorithm in generating its predictions. If the employer's end goal is legitimate, is using a race-aware algorithm legal? What if the employer's legitimate goal for using race in the algorithm is to counteract the statistical disparate impact on racial minorities that the algorithm would otherwise produce if it were blinded to race? Right? So first we have to understand how it's going to create reproduce the biases to understand how race consciousness will be able to attack the biases, but will those who want to attack the biases have their hands tied behind their back? In other words, it's almost like you see a fight and you see one party bigger, stronger than the other. You would like to help the underdog, but you actually favor the stronger person. So you claim out of fairness to be neutral, right? You claim to try to have a ceasefire or not recognize a fight, knowing that without intervention, you know that A is going to beat the snot out of B. So that's where we're dealing with this anti-classification stuff. Courts will soon be facing these questions, and the answers are not clear. Race-aware algorithms will force courts to confront anew tensions between competing purposes of discrimination law, right? Is it anti-classification? Is it anti-subordination? There's a third that they're going to talk about, Reva Siegel's anti-balkanization, and then are all three of them missing the mark when we should go back to just equal opportunity, right? That equal opportunity versus equal outcomes was supposed to be worthy, right? John Rawls and such. Anyway, law that was developed to govern human decisions, including the statutory prohibition on race norming tests and the court's equal protection rulings, may not translate readily to the governance of machine-assisted decisions. Legislators and jurists did not have in mind the possibility that powerful computing machines might be capable of formally removing protected characteristics from consideration, yet still inescapably and inadvertently reproducing pre-existing human biases by leveraging correlations. The basic problem of unintentional algorithm discrimination is by now well recognized, but again, not by some of us lay people, so I'm very thankful for a grander description. So let me give it to you here. A recent Reuters report provides an example. Amazon used a secret machine learning algorithm in recruiting employees, and it systematically favored men over women in scoring potential job candidates without it even being told. Amazon gave up on that project, but it and other companies continue to pursue algorithmic decision processes in personnel matters. Scholars worry that algorithmic decisions will evade regulation under current disparate impact and disparate treatment doctrine. Machine learning algorithms explore data to identify correlations with some target characteristic, for example, good employee. Due to this defining feature, the structure of the algorithm itself may provide a necessary business necessity defense to disparate impact liability. And because the algorithm is making predictions based on data without any discriminatory animus or intent, an employer relying on the algorithm may not be engaged in or considered to be engaged in unlawful disparate treatment. Now, as we will see, algorithmic fairness cannot be accomplished just by hiding protected characteristics from the machine. That's very important. Attempting to build colorblind algorithms is an exercise in futility. Machine learning scholars increasingly agree that the best way to get fair algorithmic results is not by hiding the protected trait, but instead by using the protected trait to set a fairness constraint within the algorithm design. Machine learning scholars are developing an arsenal of mathematical techniques to achieve fairness, some of which look like the algorithmic equivalent of weighting employment tests differently by racial group. Professor Anupam Chandra has called for algorithmic affirmative action, arguing that achieving fairness requires algorithms to take protected characteristics into account and use them to counteract other identified sources of bias. Is this legal? The question has two components: whether algorithmic affirmative action is consistent with statutory prohibitions on intentional disparate treatment discrimination, and whether it is consistent with the constitutional guarantee, where applicable, of equal protection. Data scientists have noted the legal issues but left them for legal scholarship. The few legal scholars to confront such questions have disagreed about Ricci v. DiStefano. Ricci versus DiStefano, the Supreme Court's 2009 opinion addressing tensions between the disparate impact and disparate treatment theories of discrimination, represents a legitimate threat to algorithmic fairness solutions. And beyond the threat of Ricci, there remains an equal protection challenge to state actors' use of race awareness fairness techniques to avoid algorithmic disparate impact. This article is the first to comprehensively explore whether algorithmic affirmative action is lawful. It concludes that both statutory and constitutional anti-discrimination law leave room for race-aware affirmative action in the design, but the article recommends some clarifications of current doctrine and proposes that the pursuit of formally race-neutral methods to achieve the admittedly race-conscious goals of algorithmic affirmative action. But we have to be real and clear about not just that the Supreme Court is right-leaning, but I just saw an article this week that said that 30% of the circuit court judges now in America, after 4 years, less than 4 years, are Trump appointees. And of course, and again, let's be clear. We know Trump does not know any of them. He's never met any of them. That they are more likely folks that have followed the rules and the plan of the neoconservatives that run Heritage, the Federalist, the Federalist Society, and to the extent we have Stephen Miller and all that in the White House leading the appointment process, we can guarantee that these folks will not use the court's considerable power to check the tyranny of majorities, that instead that these will be judges that believe democracy asks of judges to drive them to hell if the legislature and the people want to go there. That they're not the wiser legislature, they're not the wiser branch of government. They are just strictly subordinate pencil pushers to the legislature, according to the neoconservative regime. All right, so this paper concludes the prevailing account is that U.S. anti-discrimination law has taken a turn toward an anti-classification formal equality principle, right? That's John Roberts and the neoconservative bent, and away from an anti-subordination substantive equality principle. If so, which I believe is correct, this spells trouble for race-aware fairness constraints, at least to the extent they are understood to be racial classifications or race-based conduct, which, again, Alito, Gorsuch, Roberts, it's hard to believe that they will not see it. We know Thomas will join them. That's 5 right there, unfortunately. The implications for the use of machine learning algorithms in personnel decisions would be severe. Achieving the anti-classificatory ideal of colorblindness is impossible in the machine learning context because we cannot create truly colorblind algorithms. So as a matter of fact, maybe this is useful. Maybe this is useful to tear down asunder the colorblind construct entirely. Machines are too effective in identifying proxies, so disparate outcomes might be the inevitable result of machine decisions, and they may well be immune from disparate impact liability under the business necessity defense. But Professor Reva Siegel has advanced a third plausible explanation for the court's more recent anti-discrimination decisions, an anti-balkanization principle. And the courts have been using this to suggest that they want more racial harmony instead of classification or subordination. That their goal in squelching the judiciary's power to rectify racial situations is to reduce, to create racial harmony. In other words, to stop pissing white people off, right? To protect the feelings of white folks. If the avoidance of balkanization is the concern driving the close cases, it could bode well for algorithmic affirmative action. Race-aware fairness constraints do not create easily identifiable visible victims who are likely to feel as though they have been governmentally defined and classified by their race. And the author contrasts that with affirmative action in higher education and whatnot, where it's easier to see that, oh, this seat was quote unquote taken from me when it really wasn't. Anyway, under this view, carefully circumscribed uses of race or gender variables in calculating and applying algorithmic fairness constraints ought to be a permissible form of voluntary compliance with the disparate impact provisions of Title VII. So again, this paper is very important because it's dealing, as we see through this COVID pandemic, we are converting very rapidly and even more so since the shock into an online world that's dependent on computer algorithms and computers. Much less human contact and more machine artificial intelligence is the order of the day in dealing with this pandemic, and afterwards it's going to be a new normal. So in addressing that new normal, those of us that are scared of math, those of us that are scared of computers, we have to put that to the side and understand what's going on in this cipher towards our subordination. all of this goes back to, even again economically, to Gary Becker's color blindness when we talk about the free and fair meritocratic market, how he misconstrued it as something neutral, just as we're talking about computers being neutral. But again, this racially asymmetrical market imperfections is designed specifically to show how there is no such thing as a free and meritocratic market, that free market fundamentalism is bunk, and especially to the extent that these imperfections in the market are racially asymmetrically distributed or in place. So Gary Becker's idea that the market will eliminate racism is clearly untrue, and that was even challenged early by a scholar named Richard Epstein, who has a paper called Statistical Discrimination, that if minorities are bad at a certain job requirement, then isn't it efficient to exclude them? Not lawful, but isn't it efficient? Isn't it better for the country if black people or minorities exclude from something if in fact white people do it better, right? But here comes the question: if you flip that, can you then, you could either be doing that inadvertently, and this is a neutral quality that produces goodness and black people lack in it, or you could do it in the reverse. These are qualities that white people have that are distinguished from black, and we can use this or elevate those concerns or qualities in terms of how much they represent goodness. We can emphasize those more, right? So statistical discrimination can describe a situation in whether it's efficient to discriminate, but it also can be flipped right on its head to show how inadvertent, statistical discrimination that seems efficient is actually not. It's actually just a means of furthering the white racial cartel, right? White racial monopolies. And that's why, again, racial asymmetric market imperfections, I believe, is important to describe racism in terms of its degradation of this free market model that we seem to want, right? So we're going to put that to the side, and also and just remind folks that not from a broader perspective, not just law, that that the way in which technology and computer algorithms and technology are subordinating black people through disparate treatment relates to hiring, it relates to surveillance technology with law enforcement. There's so many applications. So if you're interested in this paper, also please buy Ruha Benjamin's or acquire in any way you can Ruha Benjamin's Race After Technology, the new Jim Code that came out in 2019. Also a great book. The author escapes me. But there's also a great book that was published maybe less than 10 years ago on a similar topic called The Weapons of Math Destruction. Weapons of Math Destruction. And again, how these computer programs and algorithms can perpetuate all types of subordination amongst class, race, gender, etc. So these are the three papers that we're presenting this week on our weekly scholarship review. Barry and Weiner on ex-offender housing discrimination. Their paper can be found in the Journal of Psychology, Public Policy, and Law. William Crozier and Brandon Garrett, Driven to Failure, and Empirical Analysis of Driver's License Suspension in North Carolina. That's in the Duke Law Journal. And then Jason Bent with a fantastic paper entitled Is Algorithmic Affirmative Action Legal? And that's in the 108th volume of the Georgetown Law Journal on page 803, 2020. So thank you for joining us on the Economic Justice Law Review. I don't think I said it at the beginning. I'm Andre Smith, Trey Smith, Smitty Bonton. You guys know or remember me from Penn State, Florida International, Weiner University School of Law, Howard University School of Law, and now the Economic Justice Law Review. So we're going to see you next week with another 3 papers for those of us that are interested in race, economics, and the law. See you next week.